Okay, it's 12:15, so we're going to go ahead and get started even as people join us. My name is Kelsey Affronte, and I'm here with Eli Neal today. And we're going to be talking to you about how financial experts, Eli is one, can help you tell your story in litigation.
Yeah, thanks so much for having me, Kelsey. I really appreciate it.
Of course, thanks for being here. Why don't we go ahead and tell them what we're going to talk about?
Okay, let's do it.
So first, we're going to introduce ourselves, and then Eli is going to talk about economic damages and provide an example. Is that right?
That's correct. We'll do a case study. It's always the most interesting.
Awesome. And then we're both going to talk about best practices at trial, both from your perspective and from my perspective. And then we will leave it open to any questions.
Exactly. Sounds like a great plan.
Awesome. So as I said, I'm Kelsey Affronte. I was barred in 2017, and I worked at I was a deputy prosecutor with Snohomish County until 2022 when I joined Beresford Booth. So my entire career has been litigation. So what we're talking about today, being in court, how you tell a jury or a judge your story. And so I have completed about 30 trials. Most of them have been jury trials. Some of the examples include timber trespass, waste claims, emotional distress, TEDRA, which is Trust and Estates Dispute Resolution, which Eli, I know we've talked about a couple of those cases together, as well as dissolutions and dissolutions with children, which I know you've also worked on, land use, spike fences. If it looks like it's going to a courtroom, I have touched it. And then a little bit about me is that I'm from Monroe, Washington, so I'm born and raised in the Seattle area, and I couldn't be happier, even though I know it just rained for longer than 24 hours. I love cats, and I recently became addicted to Project Runway, and I am rapidly binging it.
Very nice. Make it work. Make it work.
Yeah, exactly. Make it work, designers. Go ahead and tell everybody about you.
Yeah, thanks, Kelsey. My name's Eli Neal. I am a Seattle person. Grew up Queen Anne Hill, Ballard High School. I went to University of Washington. Started my career at one of the big four accounting firms, Ernst & Young, doing billion-dollar audits, and then found my niche, helping attorneys and their clients in disputes, ultimately as expert witness, if necessary, if the case goes to trial. So I've won a national award for CPAs under 40 providing this service, and started my own firm in 2020 after the onset of COVID. Moved back home, started my own firm, and we're now up to 4 forensic accounting professionals, including myself, providing great work. And I'm certified public accountant, accredited in business valuation, and certified in financial forensics. And there's a picture of my wife, Jamie, and our 2 daughters, Blair and Avery. So we're busy.
Yes. Busy at work and at home.
Yeah, exactly. And what does Four Corners Financial Forensics do? Well, I think that we provide numbers you can trust to inform good decisions. And so how do we do that? We partner with attorneys and their clients to make sure that they understand their case. So we're working very collaborative with the attorneys and clients. And hopefully that leads to settlement because they have numbers that they can trust and make decisions around. But if not, we're then very happy to explain their case to judges, juries, arbitrators, and mediators to help throughout the process. So we're always performing work kind of with the lens of trial as a potential. And what is my testifying persona when I do go to trial? And an attorney recently said that I have an aw shucks approach, which she thought the judge really appreciated. And that is, it just is what it is. If a company is great, I'll say it's great. If a company is not very good, I'll say it's not very good and explain the reasons why. And so very direct, engaging, objective is my goal when testifying. in trial. And the type of projects that we do usually fall under three different umbrellas, which is economic damages calculations, forensic accounting, and business valuations, or some mix of all three, as sometimes happens. And then I'll just jump into kind of an explanation on economic damages and the case study that I had planned just to give everyone a window in. And so what are economic damages or lost profits? It's really the difference between the actual profits that were recognized and the profits that the plaintiff would have received but for defendant's actions. And so as I explained to my mom or my friends, it's like lawsuits are great, but typically people are suing because they want some type of financial compensation. And so we
Yeah.
are putting the numbers towards that compensation. And I really like this chart, which shows the blue line, an explosion, which is some wrongful act by defendant. And then we're trying to capture what would have happened but for that wrongful act on the green line. And the red is what actually happened along the way. So we're trying to bring plaintiffs up from the actual line, considering the bad act, to what would have happened before. And so there's a lot of things to consider when projecting the unknown, because, I mean, we cannot know what would have happened. So we have to use our best estimates and reliable factors to determine, but for the bad act, what would have happened. So the case study I'm going to use and talk through today is one in which we were actually on the defense. And so
that was going to be one of my questions.
Yeah, we help on both sides of cases all the time, which really lends to our credibility in front of a judge or a jury. I mean, I would say it's very close to a 50-50 split. And the work is the same. We're trying to put numbers to situations that are reasonable and reasonably certain, which is the standard that we're going for. And so in this case, it was a car accident that happened in late 2019. The plaintiff was the CEO of a sporting goods company that sells basketballs, softballs, soccer balls, apparel to high school teams and camp. And the primary form of their compensation was through commission sales. And so not a W-2 wage earner, which, you can get paychecks and kind of map out what it would be, but the commissions aspect of it made it a little bit more gray and uncertain as far as what their wages would have been. And then our role was as defendant's rebuttal expert. And my task is, if plaintiff did suffer reduced work capacity, which is a question outside of our scope for the attorney, fact evidence, and medical experts to weigh in on. But if the plaintiff did suffer reduced work capacity, what were his lost commissions? That was my task specifically, just the financial piece.
And before you move on, I have a question for you. Sometimes experts watch other experts testify. Was this a matter where you had observed the plaintiff's expert testify?
This matter actually did not go to trial, and so this one we received plaintiff's expert report, and so we had the chance to do a rebuttal report in that case.
Got it. Okay, yeah.
And so we have a date of accident, which is October 16th, 2019. And we can see the actual commission that they received was $70,000, then $50,000. 2019 is a period in which the accident happened, so they were down to 38,000. 2020, they actually received 38,000. And then in 2021, they had 52,000. And so you can see in this case, plaintiff's alleged lost commission, they said, oh, we would have made 70,000 in commission in 2019 and 70,000 in commission in 2020, but for the accident. But one thing that jumped out to us, and I would think everyone, is, well, COVID-19 happened in 2020, and that is certainly a complicating fact with a lot of the cases that we're seeing and working on now, is that there's the run up to COVID happened, changed everything. And then we're almost getting back to normal. And so we're constantly grappling with how COVID would have impacted the industry, and
Yeah.
selling sports equipment to high schools during
Yeah.
COVID, certainly had an impact. And so we're going to capture that here. So we're saying, is 70,000 in 2019 and 2020 reasonable assumption for plaintiff's lost commission? That's our question. And if it
And
is, that's great.
sorry to interrupt you. Something that jumps out at me is that the accident occurred near the end of the year, right? 12, 14 weeks before the end of the year. So would he really have gone from 38 to 70 in that short period of time?
Exactly. See, and Kelsey, that's why it's so great to work with you, because you're trial tested and you're a very sharp attorney. And so that's the first thing that we looked at. I completely agree, which is in 2017, 70,000, 2018, full year, 50,000. He actually made 38,000 during the first 9.5 months of 2019 and then stopped working. So if we multiply that out, he was only on pace to receive $48,000. We then look at this pace and we go out and in this case, we could find an industry analysis, a report that we paid for. So it's not our assumption. We're relying on a third-party source. They have a really great reputation and even have projections for certain industries. And they showed that athletic and sporting goods manufacturing decreased 0.8% in 2020, likely due to COVID. And then in 2021, came back up 8% to account for the fact that everyone's a year behind, presumably. But it makes sense to me, kind of looking at it. And so now our role as financial expert is to think about what actually happened, what happened in the industry, and what would have happened to this plaintiff specifically. And we're kind of triangulating through all of these sources. So here we say, so this is our defendant's alleged loss commission, the table down below. We're saying he would have gone 70,000 down to 50,000, said he was on pace to make the $48,000. So we gave that to him, kept that flat rather than reducing it by 0.8%, conservative to the benefit of the plaintiff in this case. We'll just keep it flat. And then what happened really nicely in this case is that we took his actual in 2021, which was 52,000. That represented an 8.6% increase from the year prior, which matches almost perfectly to the 8.2% in industry. And so it told a really great story to match up what actually happened to plaintiff here with the industry data. And so we could show that it looked like perhaps he would have received $20,000 more across the 2 years based on what was actually happening, whereas they alleged a $60,000 loss. And so not the biggest case, but this is a really tight, compact way to show the type of data that we rely on and the marrying of facts and industry data to come up with a reasonable amount of loss. And so we used history as a guide and corroborated it with industry performance in this case.
Yeah, that's really interesting. I like this example, and I love this manufacturing 8.2 and then him going up 8.6. It also, again, lends to your credibility that you're on track with another industry expert, basically. And I have a question for you. You said that you did this conservative to benefit the plaintiff. Why would you do that?
Well, I'm always looking for places in which I can tell a trier of fact and tell the other side that I'm being reasonable. And so we're not going to go out on the limb and go for every single dollar to the benefit of my client, to the benefit of defendant or plaintiff or whoever my client is. I'm looking for places where I can say, see, look, the number is 20,000. It could have been even lower, but I'm making choices along the way to the benefit of the other side to reduce the conflict in the case and try to help the parties settle, which is ultimately what's best for both sides.
Yeah, especially when you're talking about numbers like this. Yeah, exactly. You can easily spend $40,000 on a trial.
Yes, exactly. And even if
Yeah.
if the numbers are larger, I'm always working with clients and the attorneys to think through the assumptions and the benefit of going with an aggressive assumption and why a more conservative assumption may result in reasonable certainty, which is what the trier of fact is
Hmm.
looking for.
Yeah, I like that. Thank you for explaining that.
Yeah, happy to.
Why don't you tell us next what you consider best practices at trial?
So the case that I just talked about did not go to trial, largely because the numbers were so small. But I just wrapped up a couple trials, but one at the end of December or at the end of January was a jury trial, and so
Mm.
and it's one in which the jury selected my damage number exactly, and so it's a great proof of concept for me and my firm, and reminded me of some of the important things to think about for attorneys and experts as we're going through jury trial. First and foremost, working with sharp attorneys or as a client selecting sharp attorneys is really important. And so, Kelsey, the fact that you have 30 trial experiences is just really fantastic because there's nothing quite like trial in the lead up. So that's
I
great
was just gonna say,
experience.
isn't a jury trial just so strange if you kind of remove yourself from the legal system and think about it? You're telling, anywhere from 6 to 14 people, potentially intimate details about your life or intimate financial details. I mean, I think we can all agree that, turning over credit card statements or bank statements is really intimate. I mean, you're going to see how many times somebody bought something at Starbucks. You're going to see how many, you know what I mean? So it is just such a strange thing to think about, but that's why it's so important to have people on your side that are familiar with the process.
Yes, and specifically, it would be our job or someone like us job to add up every Starbucks run if it was relevant
Yep.
and present that to the jury, and so they will know. And the other thing that I think is really important is just scripting direct. I always write out the questions ahead of time, and we don't have to follow that. It's really nice to be able um, to change on the fly, but just to make sure attorney and expert and client to the extent for fact witness testimony as well. It's just important to be all on the same page so it comes out crisply and cleanly for the jury and the judge to follow. On the other side, in that case, their own expert and their own attorney were not understanding the question that was being asked and the answer being given. And if your own team can't get on the same page, it's really hard for the jury to have faith that that's the right answer if you can't even convey what you think the answer is. So I think that's really important.
Yeah,
Something else
I
that
agree.
go ahead.
Working with an expert, you want to make sure that you talk to them beforehand because, I'm definitely not as experienced or I don't have knowledge, related to your industry. So I want to make sure that when you say a term, I'm understanding what you're talking about. And that's why it's so important, like you're saying, to talk beforehand and make sure that we're all on the same page. Because the last thing I want to do is make either of us look dumb in front of a jury.
Yes, exactly. We want to be buttoned up and just be able to very clearly articulate our point, and it helps to be on the same page ahead of time. And the other thing that I like to do is as expert, I know the details. Every detail is the goal of mine. So any number that's asked, any assumption that's asked, I'm able to explain it and understand and help the trier of fact understand why we made that assumption, why we selected it. But on direct, I like to keep it snappy and big picture. Um, in the jury trial I did have, we really just focused on the fact that the bad guys received 2.2 million and they shared 22,000 with our guy, who was more than a one-third owner. I mean, that was the message we were trying to convey. Our guy should have received more money. And we presented that in a number of ways. And then on during cross examination, I welcome the other attorney to ask questions about specific assumptions, specific details, and I can say, that's a great question. Let me explain it to you. I appreciate the opportunity. But on direct, I really want to focus on the big picture to make sure that that's what comes through for the trier of fact. Um, Another thing that we did successfully is using demonstratives, which are numbers and charts. It's really typical for me personally, because I'm such a numbers person, to just live with the number tables, all the nice numbers organized nicely. But not everyone learns that way or
Yeah.
absorbs information that way. So it's really important to also think about the judge or jury and put together charts with colors, bar charts we do a lot of to illustrate our points in a different way in case the person making the ruling uh, absorbs information in that way more than just numbers.
Yeah. Kind of give a visual to your testimony.
Yeah, and help and meet. We want to meet the trier of fact where they are. It's really
That's a really
important.
good way to put it. Yeah.
It, and I would say another thing that is sometimes overlooked is the need to make sure that the expert, the fact witnesses, and the discovery documents are all in sync. And so that is really why we want to work with Sharp Attorney to help us manage the process of making sure all of the facts play in and are moving in the same direction so that when I make assumptions, the underlying facts support it. If I don't know about a fact and it comes out in trial, it could undermine an assumption I've made because I didn't know about it. And
Yeah.
so there's been lots of times where you get to trial and on cross, it starts to fall apart because the expert facts witnesses were not on the same page.
Yeah, I mean, like you were saying, it's you can live with the numbers, you can testify to the numbers to a T. It's my job to know the case frontward and backwards so that when you and I talk, if there is an assumption that you've made and I know that there's a fact that would undermine that, that we're clear before we go to trial.
Exactly. And that's why I'm always going to be honest with attorney and client about the assumptions and unknowns and the assumptions I made to make sure that it makes sense to attorney and client. And I give plenty of opportunities for them to say, well, that's not quite how our business worked, or that's not quite how our clients operate, to make sure that we've thought about it multiple times before we ever get to trial.
Yeah, so multiple eyes on it before it gets
Yes.
to the big eyes, the fact finders.
Exactly, exactly. And
Yeah,
that helps attorney and client think about their case and hopefully settle before it
it
ever gets
does.
to trial. Indeed. Um, and then another thing that didn't happen in this trial, but previous trials, is that it's a really different skill set to have a damage expert and someone that does it all the time versus just a normal CPA, accountant, or tax CPA. I
Mhm.
mean, it's very different to think through the assumptions and think about reasonable certainty and speculation. And so every time I'm opposite a CPA that doesn't specialize in expert witness testimony, I think it's pretty clear that they're just not as experienced doing it. Um, and then last bullet point here is the aggressive assumption. If you're overly aggressive, it can really hurt your credibility with the trier of fact. And so we really want to think through whether we're overreaching or operating within the reasonable certainty framework.
Yeah, exactly like we were talking about earlier when you were talking about being conservative in favor of the plaintiff.
Yeah, it's really powerful for the trier of fact to hear that. You're just coming up with the answers, and if the right assumption benefits the other side slightly, that's great. It just is what it is.
Yeah, yeah. I thought through some best practices for clients in leading up to trial. And one thing that you and I talked about was that it's really important, and we're kind of talking about it right now, is that it's so important to tell your attorney and your expert all of the facts, the good, the bad, and the ugly. We cannot help you if we don't know all the facts, and like you're saying, it would be terrible if, you're not being honest with me about a bad fact and it inevitably comes out at trial and now your report is affected, my trial strategy is impacted. So it's really, really important to be honest with us so that we can anticipate those bad facts and figure out how to work them into a positive fact for your case. And if not a positive fact, then how are we going to rebut it when the other side grabs onto it? And you were talking to me about an example with a cannabis grow operation.
Yeah, we just had one come up where initial meeting, they said, a bad action happened. And so it's a question of how much would they have sold their cannabis for that they were growing. And so initial call, client told us, oh, we always grow cannabis above 20% THC level. That allows us to reach a higher price per gram. So financial expert, when you're doing your work, you should use that higher price. And then we said, that's great. But also, please give us the details of your previous grows so we can, and testing, so we can see what your average THC level is, because that will help the other side understand why we're commanding a higher price per gram based on the THC percentage. Ultimately, we get the prior testing data, and it is not an every time we exceed 20%. It's more like 75% of the time we get less than 20% THC, and only 25% we do. And so we had a long talk. And again, I like working with attorneys because they're on the same page as me, which is if we project we're going to get above 20% and we haven't done that regularly in the past, the other side's going to take our report and our damage and settlement proposal and just throw it out the window. And so it really is necessary to be honest with yourself about what's most likely to happen and present that to the other side. So eventually, client, myself, and attorney all got on the same page that we can present two scenarios, one with 25% above, one with 50% above, because they were improving over time. And I think that was more palatable to the other side, certainly, based in reality.
Yeah, exactly. That's what I was just going to say. The facts supported what you're giving the other side, and that's what's most important.
Exactly.
Yeah, I recently had a matter related to some bank statements that were modified, and I kind of want to ask you about this because your job is to kind of chase the money. So how easy or difficult would you say it is for people, let's say in a divorce case, they've hid some money to try to reduce their child support obligation, or they've modified their bank statements, and then obviously the other side is going to subpoena the bank, and that's going to come out. So I guess my question to you is, you're getting in the weeds of these numbers. How easy or difficult is it to kind of try to hide things from a court in these situations?
Yeah, I think it's not a good idea, and it's really hard to hide it, because when we're looking at the existence of funds or corroborating bank statements, I mean, there's just a lot of evidence out there to triangulate. And so you're thinking about W-2s, tax returns, bank statements, pay stubs, and we're looking through the detailed transaction and adding it up. And at the end of the year, does it make sense? Do the tax returns and pay stubs support how much made it in the bank? And if not, where did it go? And so I think it would be really hard to get away with something like that, and ultimately just not a good idea. So I guess I wonder how that went in your example.
Yeah, I mean, it's again, like one of the first things I tell my clients is please be honest with me, because like we just talked about, if I don't know something and it comes out later, I can't save you at that point. And I like to think about the financial side of things very similar to the way that we think about, criminals, in a sense of like, we are in a modern day, we have modern day technology. It is hard to get away with a crime. So I think it's equally as hard to try to, hide some financial resources as well, especially when people like you are going to be looking at, the other side's bank records or my bank records, and you're going to be able to corroborate, like you're saying, whether that all adds up at the end of the year. And I think that goes nicely into our next point, which is just be realistic about your expectations. You know your finances, better than we do, at least at the start. So if you're starting realistically, then we can help you on the backside, like you're saying. Once you're giving that conservative estimate, we can help you get the parties to talk and have settlement discussions that are, going to be more worthwhile than otherwise, maybe if we didn't have your support.
Yeah, exactly. And it's similar to, it's going back to the cannabis example, where it's great for you financially if you can get the other side to pay based on a 20% or higher THC number. but they have someone like me on the other side thinking about it, the assumptions, and a sharp attorney on the other side thinking about the assumptions. So it's really unlikely that you would pull a fast one and settle based on that. I mean, we don't want to hit a grand slam. We want to hit a nice double to the gap and just keep it and get what is fair and reasonably certain and move on. And so that's something that I counsel is if you go for the 100th percentile outcome at every turn, it's going to make it really hard. But if you just go 85%, 90th percentile with your assumptions, it's going to compensate you fairly and have more likelihood of the other side agreeing with that.
Yeah, and kind of to jump off that, I mean, a lot of the standards for fact finders is what is fair and equitable. And so if you're already going into it thinking about what do I think is fair and equitable, then you're already a step ahead as far as what is likely to happen at trial, because that is kind of the same standard as what is fair, what's reasonable. And so that's a great way to be thinking about it going into trial. But also, people should be following, our advice. Not only do we know the system, but you now know all the numbers frontward and backward. I know the facts and the law frontward and backward. And so, like we're talking about, being reasonable, approaching settlement seriously, all of those things, because we've been in it, we've done it, and it's likely a client's first time even being involved in the judicial system.
Yeah, and I don't want to be misunderstood. I mean, I'm always considering the client's perspective and attorney's
Absolutely.
perspective. I just want to understand and make sure there's a good reason behind their assumptions and why they think it would have happened, because then I can take that and testify to it. But we're pressure testing along the way because we know the system, as you said.
Yeah, exactly. So I think that about wraps things up. But I left our contact information here in case anybody wants to learn more about what Four Corners does or how we work together. So I also included our website and my contact information. Is there anything you want to leave the people with?
I think I want to say plaintiffs, defendants, we want to put numbers to your story and help you. And we want to be a trusted part of your team throughout. So if we can, please reach out. We'd love to help. I'd also say go Mariners right around the corner.
Yes, exactly. Well, thank you so much for your time today, Eli, and I look forward to the opportunity to work together again.
All right. Thanks, Kelsey. Thanks for having me.
Of course. Take care.